Hi! On my back end, it is showing me some errors, some difficulty with streaming. So if this isn't working, then I might have to redo this. I don't know. Because sometimes that's happened before where like I've done a whole live stream thinking it's like recording and on and streaming, and then it turns out it wasn't. But for the first time in a minute, I am actually early to one of these. And I had decided to do my hair. So, I'm working on that. I used to do my hair all the time in high school. And then in college and afterwards, I got so busy, I kind of stopped doing my hair as much. I mean, I did do it when I was working in the service industry. I would make sure I kept it up. So I actually did have it up a good bit in updos for the service industry. But I don't know, man. I'm working on figuring out how to do my fucking hair again and shit. And keep this out of my face. Fuck it. It's just gonna be my face today. So sorry, distracted. But anyway, for the ladies wondering though, I used the soft foam rollers, and I used mostly the biggest ones, except for face framing. I used the second biggest, but then the rest I used the biggest. I don't know, for the, like, I have a little mixed variety thing of like the little foam roller whatever things. Okay, I'm sorry, I'm distracted. Alright, so what we're actually here for today is I'm gonna go over the process. I submitted a complaint to the Louisiana Disciplinary Board, technically through the Office of Disciplinary Counsel. So today in this live stream, we will be going over what the fuck the difference is, but if I understand correctly, the Office of Disciplinary Counsel is part of the Disciplinary Board, where they're the ones who handle the complaints and all of that, if I understand correctly. So what we're going to do today is kind of, I'm going to recap a little bit, not too much, what happened with the law office situation, and just enough for context of this stream. And then we're going to go through the Attorney Disciplinary Board for Louisiana. I'm not using the right words. We're going to go through their website, and then we're going to go through the, so we'll watch some videos they put out too. And then we're going to go through the, what is it called? The rules or whatever? Hold on, let me see what the fuck. The rules of professional conduct. We're going to go over which rules I believe are violated. And then we'll also finish up with reading a Reddit thread. But yeah, so unless they just don't respond, then that's like another 2 weeks that they would try and get a response from, And so that's a month, right? So I was expecting by the end of September, maybe give or take those time windows and delays, I would know something by now, but I don't know anything yet. I haven't been told anything yet. So I don't know what's going to happen. Last time I was thinking, whenever it came to the EEOC situation, I was like, well, they wouldn't be taking this long on my case if they didn't think I had one. And I was like, maybe they're going to go through with something for me. But literally, I recorded it myself saying that. And like the next day, I think, or a few days later, I think, if I'm not mistaken, is when I got the notification for everything, where I found out that they were not moving forward with me, even though I did get the right to sue letter. But yeah, so then, to save resources if I didn't have something valid here. And part of me is just like, well, that didn't mean anything last time, so, but at the same time, it is two different things. And I didn't, even though I had a lot of evidence for events that happened around what I believe was discrimination, through the documentation and everything, I don't have evidence besides my own record of what happened in that room. But when it comes to the fraud case, I have the evidence. It's right here. It's in writing. It's in letters, in my understanding. If I am understanding what happened correctly, because maybe legally I don't. That is a possibility. But yeah, if I understand that shit correctly, like, I have the evidence. I have the smoking gun. I've got everything in writing. I got pretext. I got it all. Like, there was no debate. If this happened, I have the material. I can forward these bitches the initial original emails, like, let's go, you know? So in this situation, I am hoping that perhaps I will be heard or seen. The captioner put hurt. I said like heard, but you know, yeah. Anyway, I apologize for this weird ass ramble. I'm gonna roll my intro and then let's just like actually do this bitch. Yeah. Hi, my name is Alexis, also known as Lexie or Deaf Child. I was born deaf, hard of hearing. I began doing business as Deaf Child 2013, marketing 2011, sales 2009. I've earned 50 plus certifications in marketing and sales. My Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Deafness runs in my family genetically. Speech is not fully accessible to me. Anyway, I'm here to bitch about whatever the fuck is on my mind. So here we go. Visit my site at noladeafchild.com. Okay, so I feel like normally my voice can change through a variety of like a range in how I sound, I feel, because I'm very emotional when I speak, and so like my emotions I feel alter how my voice comes out. But today I feel like my voice is like lower than normal, and I feel like I have two types of sick voices, you know. Either my voice gets like raspy and it's not necessarily high pitched, but it's like on the higher end of frequencies and raspy, and it's like I feel like I have no voice to speak. Or my voice goes lower somehow. Like whenever my throat hurts, I feel like my voice is lowered and flatter than it would be normal. I'm not speaking. I don't know if anyone else knows what the fuck I mean, or if I'm just crazy, but that's how I'm feeling right now. My voice is still feeling weird to me. My throat is still hurting. I do still feel sick, but I am feeling a little bit better than I was a couple days ago. So yeah, fucking. Right now we're gonna go over the Louisiana. Oh shit, I'm not bringing this up. Oopsie. So fucking, we're gonna go into the Louisiana Disciplinary Board website and just kind of check that out. Let me zoom in here for our viewers, for the couple of people who regularly watch me. Thanks, guys. And also, I am house hunting. I've began my packing process. The reason the books are still on the fucking floor was because my shelves had broken, and I was just like, I need to figure something out, but then we're moving anyway. And so I'm just like, you know, I don't know. But I'm in the process of getting my shit together, getting everything. This is all about to change anyway. But fucking, so the website, if I can focus, the website, it says, you know, about a little bit about them. It says in 1990, the Supreme Court of Louisiana established the Louisiana Attorney Disciplinary Board. Oh shit, I forgot to recap. Whoops. Fuck it. Okay, I'm gonna read this page and then I'll recap. Alright. In 1990, the Supreme Court of Louisiana established the Louisiana Attorney Disciplinary Board, a statewide agency to administer the lawyer discipline and disability system. Members of the Louisiana Attorney Disciplinary Board are appointed by the court. Both lawyers and non-lawyer citizens are appointed to serve on the board. Board members volunteer their time in service of the mission of the board. The primary purpose of the discipline and disability system is to protect the public. To accomplish this purpose, the agency investigates complaints of lawyer ethical misconduct and makes recommendations to the Louisiana Supreme Court when discipline is warranted. So, the reason we are here today, you know, related to the disciplinary board is potential misconduct, I believe. I guess I did kind of summarize it in the intro, but basically I linked in the description of the video. I don't think this will get too long, so it'll probably stay there, but sometimes shit gets moved to the comments if needed during time stamping. the Captioner put standing, that should be stamping. But yeah, so in part one, I explained how I believe I experienced discrimination related to accommodations, an ability to process information, having time to speak, related to other forms of discrimination as well surrounding the experience. And from there, we went into part two, and in part two, everything in part two is also in part one, because everything that I had almost basically in a lot of ways, the same information that went into the EEOC complaint went to the state board complaint, but the reason I was complaining to each person was different. But the situation and the evidence I had about it was the same, because I believe that fraudulent paperwork was filed after I was discriminated against, because of me being discriminated against, where they tried to claim I quit even though I was fired, and I can prove it. And so from my experience, from what I believe happened, if I understand correctly, legally and all that. So yeah, so in that documentation, in those emails, I had asked the managing partner directly if I was fired. He told me basically, in other words, but to sum it up, to ask somebody else. And fucking those people were CC'd. And instead of, the reason I had asked if I was fired as well is because he sent me home, but then he removed me from the company Slack, and he removed me as a Facebook business admin, and I believe my meeting may have been, I can't remember when at this point off the top of my head, now a year later, if my, I know for sure meetings were canceled the next day. But yeah, I know for sure I was removed from Slack and business admin. And so, but yeah, so those things happened. And so I'm waiting for the response, and they say that that I quit because of the conversation, because of my email where I asked if I was fired. They said first reason they gave to me was because of my email, that meant I quit. And then they were trying to say that because I didn't show up after they put me out of Facebook business admin, after they removed my access to Slack and denied me access to be in their digital space, and I had asked if I was fired, but they didn't answer me, giving me an answer on if I should come back or not yet. They said that meant I quit. And so then when I explained to them that I didn't believe I had consent to be in the office based on those issues, and that I had requested permission to see if I could come back or what was the status of my employment about being in the office, and this was the response, then they tried to say that I had unprofessional conduct. And so that I would have been fired anyway. And I'm highly summarizing right now. These aren't necessarily the word for word of what happened. I am highly summarizing off the top of my head. I explained to them I was never informed of anything that could be considered unprofessional conduct. The closest thing that came to it would be, first I was given permission to curse because they were cursing at me, and then they told me not to curse anymore, and so I stopped cursing. But I didn't know what type of environment it is. I know I do curse a lot on my own YouTube channel and platform as a default, because that's just who the fuck I am as a default. Like, I do curse a lot. I am a cursor. But, fucking, like, if you tell me not to curse, I'm not going to curse. And I didn't just go into it cursing. The dude was literally pushing me to curse. He was like, you can curse, because I wasn't cursing. You know? Because that's not my default when I go into a workplace. I don't, unless everybody else is, and I'm like, fuck it. But You know what I mean? So everybody else was cursing, but they didn't want me to curse. And then they tried to act like I was unprofessional for cursing. And so I was just really fucking confused because I'm like, I don't really give a shit one way or the other, but it felt like this weird thing that they were using to control your behavior in a way, because the reason I felt that way was because it's like they were acting like I could curse sometimes, but not all the time. But if you know what I mean, like they were encouraging me to curse because they were like, yeah, we're cool here, curse, we curse. And then when I curse, they're like, we don't curse here. And I'm like, oh, you said you did. So you can see why I'm confused, right? And it's like, I don't care one way or the other. I respect it either way. But it's just like, you could see why I'm confused though, right? Like, you know what I mean? Like just be consistent, damn. I'm sorry. That was a weird ass ramble. But anyway, so then I explained, well, I didn't say it like that, like in this explanation summary to them, but I explained, basically like, yeah, the fuck, in other words, and you can go see that in part 1, part 2. And then, so then when they couldn't come back on that, they gave me a third reason, and I had written it out too. Let me see. They gave me a third reason claiming that I was fired. Oh yes, they were basically trying to say that my emails where I was arguing that I did not believe I quit, that I believe I was fired, was me quitting. If I'm not mistaken, if I interpreted everything correctly, I remember off the top of my head correctly. And so I explained, that I didn't believe me arguing to keep a job was evidence of me quitting. And I didn't understand where they were getting that from. And I would love to clarify. And I also explained and I outlined all of their handbook procedures that I attempted to follow and how, according to their own fucking procedures and policies and manual, I was in compliance with their manual. And that I shouldn't have been fired for following their procedures. And you know what I mean? And I was attempting to get clarification on anything I didn't understand about the procedure, but they didn't give me that. So yeah. Because, in my opinion, I felt like they weren't being people of their words according to their procedure. But that's just me. So, after all of that, where they literally admitted in writing to me that they wanted me terminated anyway, because, they put that I resigned on paperwork. I do not believe I resigned. The way they treated me may have made me want to quit, but I never actually fucking quit. So, yeah. And in the documentation, not only had I asked in the emails, not only had I asked the managing partner himself, and he authorized HR to then say those things to me. HR told me in the emails that the managing partner was the one telling her to say what she was saying to me. She told me that in the emails, that it was the managing partner authorizing her. In my opinion, is my interpretation of if I understood it correctly. So that's where I'm holding the managing partner accountable. And in the EEOC situation, in that filing, all of these details are in there. He reviewed and went through the EEOC process. So even if he had potentially decided to let HR handle it and not necessarily had authorized her to handle it, but not necessarily knew about or authorized the exact words she told me or what she did with the paperwork, with the filing, then he would have found out with the EEOC issue. But he still kept her. Between now and then, she's still there as far as I'm aware from what I can tell. So he's aware of everything that I just told you He's been aware for like a year now. Still kept her. So that, in my opinion, shows that he's in compliance with her behavior. If, like, even if he was going to try and argue he didn't know what happened when it was happening, there's no way he didn't know since the EEOC filing, in my opinion. Because are you going to convince me that you as a managing partner didn't review your own EEOC case? So keeping her shows that he, in my opinion, condoning that. It's a collusion, in my opinion. But again, I'm not an attorney. I've just worked at a few law firms. So yeah. All right. So now we're going to get back to going through the website. And before I do that, though, for more information, part 1 and part 2, those 2 videos. So I have a whole playlist of this shit, you know, like anytime I mention them that I can recall. I've probably bitched about them in other content without thinking about it. But I feel like anything that I may have said is probably just redundant or repetitive of shit that I've been saying. So I made this playlist, and everything that I've said in regards to mentioning the law firm that I'm aware of, that I've kept track of, is in that playlist. So, and in the timestamps, I try to make sure I put where what I say is, you know. So anything like related to me bitching about this situation is in this one playlist. And then, but I've only done 2 videos that are actually covering the situation with the evidence of it, and that's part 1 and part 2. Part 1 is the EEOC case. Part 2 is the Office of Disciplinary Counsel complaint, as well as the complaint I sent to the Louisiana tax fraud people, bitches with Louisiana Workforce Commission, you know what I mean? So yeah, so those 2 videos, if you watch those 2 alone, you'll know what happened. The other videos are just additional things. So, an additional commentary. But yeah, alrighty. So I think I just read this shit. So I had just read to you guys the homepage for the Louisiana Disciplinary Board. And so I believe that if I am correct about my understanding of what happened with the fraud case, that is misconduct, and it has to do with ethics. And I do believe that he should be held accountable, and I believe that he should be put in a situation where they are just keeping an eye on him and his firm in case something like this happens to anybody else, you know, in my opinion. But that's just me. So the overview of this, and we're gonna watch this little video too. But it says that the Louisiana Attorney Disciplinary System, the Louisiana Supreme Court continues to address public concerns regarding attorney misconduct. In 1990, the court established the Louisiana Attorney Disciplinary Board, which became the first attorney disciplinary system in the nation to incorporate the American Bar Association model rules for disciplinary enforcement, the hallmark of which is the use of non-lawyers in the disciplinary process. The Louisiana Attorney Disciplinary Board is tasked with the responsibility of investigating all allegations of lawyer misconduct and making recommendations to the court when discipline is warranted. The agency consists of a statewide board, hearing committees, disciplinary counsel, and administrative staff appointed by the board and disciplinary counsel. The Disciplinary Board. The Disciplinary Board is composed of 14 members who are appointed by the Louisiana Supreme Court. 1 member is nominated by Louisiana State Bar Association each year and must have prior lawyer discipline experience. Of the 14 members, 4 are members of the general public with diverse backgrounds. Women comprise 35% of the board, and minorities comprise 1/4. This wording bothers me. But, let's see. So what they're saying, though, is it's like, well, you know what, it's the legal field, so we already know that. Never mind. I was just going to say it's another white-dominated space. But the term of office for all board members is 3 years, and no board member may serve more than 2 consecutive terms. All members volunteer their time and services. The board itself is divided into 2 committees, a 9-member adjudicative committee and a 5-member administrative committee. Still have no fucking clue if I'm saying that right. 3 of the public members serve on the adjudicative committee, and the remaining public member sits on the administrative committee. Each committee has separate duties and powers, although both committees have joint responsibility for some board functions. The adjudicative committee functions as an appellate court. Am I saying that one right? I don't know, man. In the disciplinary system. Specifically, the committee reviews findings of fact, conclusions of law, and recommendations of the hearing committees with respect to formal charges, petitions for transfer to and from disability inactive status, and petitions for reinstatement, and prepare its own findings and recommendations for proposed discipline, which are filed with the Louisiana Supreme Court. In addition, the adjudicative committee has the power to administer reprimands, issue admonishments, impose probation, and rule on procedural matters. Yeah, honestly, I don't know what the fucking admonishment means here. In terms of reprimand, I think that they can do, if I'm not mistaken, I think they can choose to do either a public or a private reprimand. So sometimes if they don't do something that bad, they might get a slap on the wrist and it's like kept private, but then it's still on their record, but it's just not made public. And then sometimes it's definitely made public, if I understand that correctly. I have no fucking clue what the hell an admonishment is. Let's look that up. Okay, I guess it's a type of reprimand. I don't know. Anyway. Yeah. And then it says the administrative committee is charged with appointing hearing committees and with the overall management of the system, including financial, facilities, and human resources. The members of the administrative committee do not participate in or vote on matters involving appellate review functions of the adjudicative committee. The administrative committee also researches various trends in lawyer discipline and makes initial proposals for Louisiana Supreme Court Rule something amendments to the remainder of the board for consideration. I'm like, you know what? I know I suck at reading the Roman numerals. I'm not even gonna fucking try it, because when I fuck that up, everybody's gonna make fun of me. Okay, now I want to Google it. Because I know that like the X means like a 10, right? Am I wrong for thinking that? I know that I is a 1, but an I and an X, when I see that by itself, I would think 9, but then this don't make no sense. So, you know what I mean? Is it like 19? I don't know. Is X 19? Let's see. Oh, it is! Hey! Okay. Anyway, sorry. I suck at reading those though. Yeah. I mean, I guess I can figure it out, but every time I see those, I'm like, fuck. Yeah. Anyway. What was I? Did I finish reading this? Who knows? Such issues include prescription for ethical complaints and changes to the probation system. In addition, the public outreach program currently underway around the state was implemented by the Administrative Committee. Administrative staff is appointed by the board to administer its day-to-day operations. The staff includes the board administrator, deputy administrator, docket clerks for filing and other clerk of court functions, staff attorneys, and support personnel, and is located somewhere in fucking Metairie. Who gives a shit? All activities of the board also take place at this location. Hearing committees. Currently, there are 50 hearing committees around the state, although this number changes periodically. Each hearing committee consists of 2 lawyer members and 1 public member. One of the lawyer members is appointed, I cannot speak, read my mind, is appointed as chair of the committee. Hearing committee members serve 3-year terms and may not serve more than 2 consecutive terms. Like board members, hearing committee members volunteer their time and services. The hearing committees are divided into 2 tiers, each with assigned powers and duties. Primarily, the hearing committees in Tier 1 conduct hearings into formal charges of misconduct, petitions for reinstatement or readmission, and petitions for transfer to and from disability inactive status. Following the hearings, the committees submit to the board written findings of fact, conclusions of law, and recommendations for proposed discipline. The hearing committees in Tier 2 review dismissals of complaint by the Office of Disciplinary Counsel upon a request for review by the complaining party. Why am I saying company? What the fuck is wrong with me? By the complaining party. I'm not speaking. Yeah. The chair of each hearing committee has additional duties, such as conducting pre-hearing conferences, ruling on pre-hearing motions, and reviewing private admonitions proposed by disciplinary counsel and accepted by a lawyer respondent. Perhaps that's what when I was saying like the difference between a public and a private reprimand, maybe that's it right there, like what they call each one. But yeah. And then it says, hearing committee members are appointed by the Disciplinary Board's Administrative Committee. Nominees for the position of hearing committee member must complete an application and agree to a background check. Also, the nominees must meet the following preliminary qualifications. Okay, I'm not going to read that, but they must meet some preliminary qualifications and shit like that. Oh, you know what? Now I do kind of want to read it. Sorry, I am reading it. 1. A nominee, they must possess good moral character and fitness to be a hearing committee member. They must hold a Louisiana law license that is in good standing with the Supreme Court, must have been licensed to practice law for 5 years at the time of appointment. They cannot be a partner, a shareholder, or an associate of a law firm that already has 2 partners, shareholders, or associates that are currently serving as hearing committee members. Cannot serve on a bar association grievance committee at the time of the appointment, and cannot hold elected or appointed political office for a term lasting longer than 30 days at the time of appointment. Office of Disciplinary Counsel. So this is who I actually sent my complaint to. And so my understanding is that the Disciplinary Counsel is part of the Disciplinary Board, if I'm not mistaken. But I could be wrong. Like, it could be separate, but part of the disciplinary process. I don't know. But look, it's all connected or some shit. Anyway, it says the next component of the disciplinary system is the Office of Disciplinary Counsel, ODC, which is charged with all prosecutorial, I'm not saying that right, prosecutorial functions. No, that doesn't sound right. Is that right? It doesn't sound right. I don't know. My mind's not right. Anyway, ODC is responsible for screening all complaints, investigating complaints and petitions for reinstatement and readmission, and making decisions as to their disposition. In this regard, ODC may dismiss a complaint or recommend probation, private admonition, a stay in proceedings, the filing of formal charges, which must first be approved by the chair of a hearing committee, or petition for transfer to and from disability inactive status. Other duties include the maintenance of permanent records of discipline and disability matters, and the compiling of statistics to aid in the administration of the system. Administrative staff, appointed by the Chief Disciplinary Counsel, is responsible for handling all prosecutorial. I don't think I'm saying that right. That doesn't sound right, man. I don't know. Maybe I am saying it right, but I don't think I am. Who knows? All prosecutorial shit, the fuck is wrong? Yeah, that word. Functions of the agency. In addition to the Chief Disciplinary Counsel, ODC staff includes Deputy Disciplinary Counsel and legal assistants. ODC staff is located somewhere in fucking Baton Rouge, and all complaints regarding the attorneys are received and processed at this location. So yeah. Now, the fact they have not dismissed my complaint yet, as far as I'm aware of. If they have technically dismissed it, I just haven't gotten the notice yet. So So as far as I know, I believe, to my understanding currently at this time, if I am correct, that my case is currently in the investigation stage. And we'll go over that in a minute. But first, let's look at this disciplinary system overview video. And if you notice the pixelation on this original video, if you go to the file, that happens whenever you stretch a file bigger than it has the quality for. So every time you create a file, you are creating it to be certain dimensions. And if you try and expand the file past the dimensions you created it for, then it will pixelate. And the reason it pixelates is because there's not enough data to fill in the squares for the image, because it's being stretched past the capacity that you told it that it would be, if that makes sense. But yeah, so I'm very interested about how pixelated this file is though in the video, because for people like me, I get it, where we're just kind of getting going in business with what resources we got, fuck it. And so a lot of times, I end up using cheap shit. And even if I know how to make something better quality or a bigger quality, it will reduce my file size, it will compress my file and take information away and make it a lower quality file, because that's how a lot of free versions work, and then you pay for the higher quality on a lot of things. Like if you add captions to something, a lot of times it's going to reduce that file quality for you. I said file, but the fucking caption didn't get that right. Anyway, so things like that. So sometimes I get that it's just like an unavoidable byproduct of being cheap in business. But in this case, like, I know, like, it doesn't even require extra resources to make the file big enough for YouTube. And if it's just for, like, my own personal documentation, I'm like, I don't give a fuck if it's perfect or not. So I'll do shitty, lower quality files for myself. But that's when it's not for business. It's for me expressing myself. And there's a difference, right? Versus when you're representing yourself and you're the Louisiana Attorney Disciplinary Board, I really want to see a better quality file here. Like, because what the hell, man? Anyway, this is what our tax dollars are going for. Okay, I'm sorry. Actually, why am I even saying that? Our tax dollars have nothing to do with this. The attorneys pay for that. Life is hard. Anyway, okay, I'm actually watching this video. I don't know what's wrong with me.
Hello, my name is Clancy Dubose. As a journalist, I often see lists that put Louisiana at or near the bottom. That's a distinct.
This file is very quiet to me. I tried making it louder, and it's just like, I don't know, it's just really quiet. I don't know if anybody else can hear it.
Distinction that many of us in Louisiana would like to change. In 1990, the Louisiana Supreme Court started something to reverse.
Honestly, this file is so old, this video looks like it's from 1990.
That trend. That year, the justices created the Louisiana Attorney Disciplinary Board, and our state became one of the first in the country to adopt the American Bar Association's model plan for attorney discipline. That action is important to me for another reason. You see, I'm also a licensed attorney, and as an attorney, I'm aware that many people don't trust the legal profession or those who practice law. By taking the lead in attorney discipline, the Louisiana legal community wants everyone to know that we are dedicated to building public trust and restoring confidence in our profession.
So, public trust and confidence. That is why I went forward with my complaint, because how can the public trust a legal system in which it's normalized for fraudulent paperwork to knowingly or intentionally be filed, in my opinion, based on what we've discussed so far, if I understood all of that correctly. Like, it really did break my trust. And because when you break your word to me, it's one thing to make a mistake. And it's one thing, I understand how sometimes in the process of the human condition, you can come off as a flake or breaking your word because you're not able to follow up on something, but you didn't even mean to not follow up on it. You were just caught up in other shit, perhaps. I can kind of understand that to a point and give grace to a point, but when you aren't making efforts to make amends or to rectify harm done when something really fucked up happened to somebody who works for you, and you're a lawyer and you are aware of your HR filing false paperwork on employees, and the employee can prove it, their side is true through the emails, then I do feel that that does create a situation in which you're potentially, acting in a way that is unethical and reduces public trust and public safety in the legal system. Because if you're a lawyer, you're the one who's supposed to protect people from these things, not perpetuate it. And if you're perpetuating what you're supposed to protect people against, how do we trust you to protect us? So that concept is a big part of how I ended up filing after thinking about it. Because at first, my first reaction was I don't want to do that, because I understand how in anti-discrimination journey, because we are all born under the construct of colonialism, it's very easy for any person, no matter how much anti-discrimination work you've done, if you don't have a lived experience to know what it's like to experience a form of discrimination, then it's very easy to perpetuate it because we don't know better. And so I never judge people for being ignorant, and I understand what it's like to be ignorant with anti-discrimination and to be the one discriminating. And I don't mean to discriminate, I'm just a fucking dumbass. So when I was first processing it, before the email conversation continued with HR, my first reaction was I did not want to take legal action because I'm a business owner, and I know how these things can impact your ability to make a living, and not just your ability to make a living, but everybody who works with you, your clients and your employees and your staff and your team and all of that. So I understand those things, and I understand learning. Like, you won't learn to do better with anti-discrimination if you only feel like you're just being punished when you do wrong, but you're not given the resources to do better or to learn why what you did wrong was wrong. And so that's why when it first happened at this point where I really wanted to just try and talk it out, and maybe I thought maybe if I could explain the history to them or something, they would understand why it was discrimination and harmful and would be amenable to adjusting their behavior going forward. Because I do understand what it's like to be ignorant, and to want to do better, but to have made a very bad mistake. So my first reaction was in that mindset of, and it's also another thing too is, I said I wasn't going to bring this up because I wanted to do lighter themed topics, but it's what's on my mind, so I'm bringing it up. What is really bothering me is I never was able to get sexual justice for my sexual assault. And that's what I would rather be focusing my energy on, because I'm discriminated against no matter where I go in life. No matter what, no matter where I go. I experience it everywhere. So for me, when people are like, oh, if you're just being discriminated against somewhere, you should just leave, it kind of feels like people just don't want me to exist in those spaces then, rather than being open to changing to not discriminating. You know? Because I'm always going to exist, no matter where I am. Like, I don't know, until I die, right? But then it's like, I you can only choose your battles as well. You can't fight every fucking battle. And the battle I'd rather be fighting is that other battle, not this battle. But because of this situation, that did put me in a situation where, you know, previously I wasn't able to speak about it because of certain things, but because of this situation and how I am speaking out on it, I think that is helping me determine ways in which I could try to speak about my situation again. So that is, you know, something that came out of it that I could potentially use. But yeah, I don't know how I got here, but we're here now. We're gonna keep watching this fucking video. My bad.
Working with the Louisiana Attorney Disciplinary Board, we want to remove the relatively few bad apples who are tainting the image of the legal profession. So join me now in learning more about the Louisiana Attorney Disciplinary Board and how our state's attorney disciplinary system works to safeguard the legal system, the legal profession, and most of all, you.
Yeah, the low file quality is fucking killing me. And this shit, okay, it really does look like early 2000s, like early 2000s, late 90s is the energy right now from this video. But anyway, so this is basically just in a nutshell about the disciplinary system, and also in a nutshell, just kind of like me processing how I end up filing, just to begin with. So they also have a different section about the purpose of discipline. And in here they talk about how the purpose of lawyer discipline is to protect the public, protect the integrity of the legal system, ensure the administration of justice, deter further unethical conduct, rehabilitate the offending lawyer, deter unethical, am I saying that right? Who knows? Unethical conduct by educating other lawyers and the public. Neither the Office of Disciplinary Counsel nor the Disciplinary Board provides legal services or gives advice to anyone filing a complaint. The complaint process should not be viewed as a substitute for a civil action for damages against a lawyer. The disciplinary system is not designed to compensate a complaining party for monetary loss or emotional distress incurred as a result of unethical conduct. Anyone seeking to recover money damages should consult another lawyer to discuss bringing a civil suit against the original lawyer for money damages. In my case, I couldn't find a lawyer to take my case for any of it. And I tried, and I'm at a point where I just feel like me trying to continue to reach out to random lawyers just comes off spreading the information around if so many have denied me. But if you are an attorney in Louisiana who sees any of my videos before February 2026, not February, June 2026, because that's when the statute of limitations is up on the fraud case. If you see this before June 2026 and you're an attorney in Louisiana and you want to take my case, holler at me. Yes, I can pay your bitch ass. You're not a bitch. Maybe you are. But if I call you a bitch, it's because you're my bitch. Okay, I'm sorry. Standards of professional conduct. The Louisiana Supreme Court has adopted high standards of ethics and professional competence for lawyers who practice in Louisiana. These standards are reflected in the Louisiana Rules of Professional Conduct. When lawyers enter practice in Louisiana, they obligate themselves to uphold the law. The fuck am I saying? To uphold the law and to abide by the rules of professional conduct. Lawyers who violate these professional and ethical obligations are subject to discipline. Lawyers in Louisiana, not taxpayers, pay for the disciplinary system by paying an annual assessment to the Louisiana Attorney Disciplinary Board. This statewide agency was established by the Louisiana Supreme Court in 1990 to handle attorney disciplinary and other regulatory matters. What constitutes unethical conduct? Because disciplining a lawyer is a serious matter, it takes evidence, proof of unethical conduct, to justify disciplinary action. An honest disagreement about how a case should be handled does not constitute unethical conduct, even if the outcome of the case is disappointing. While it is impossible to list all of the acts or omissions which may constitute unethical conduct, here are a few examples of prohibited conduct which, if proven, may be cause for discipline. A lawyer cannot or will not give a client that he or she is holding on the client's behalf. Oh wait, what am I saying? That's not saying money. A lawyer cannot or will not give a client money that he or she is holding on the client's behalf and to which the client is entitled, or will not provide the client a complete written accounting for that money. A lawyer continually fails to respond at all to inquiries by the client about the client's case, to tell the client about court dates, or to appear in court, where the problem is simply a lack of communication. A client should first try to resolve the problem with the lawyer. A lawyer advises a client or anyone else to lie, or lies himself or herself in the course of a case. So right here, this part, a lawyer advises a client or anyone else to lie, or lies himself or herself. Now, if the managing partner just assumed I quit or just thought I was quitting based on us, based on this situation that occurred, I could understand a small, initially I would have understood like a small bit of misunderstanding there, right? Where I could see some argument for misunderstanding. But as that email progressed and I explained my side, and I outlined how I'm following the policies and the procedures, if I never quit, it's one thing for the managing partner to have assumed I quit and maybe communicated that he thought I quit to HR, and then HR was basically like, yeah, well, we decided, like, he said he quit. So I could kind of understand if there was a miscommunication and a misunderstanding in that telephone game there, how maybe it wasn't an intentional lie, it was just a misunderstanding. If like the managing part, if that was the case though, why would the managing partner not fire HR after the EEOC situation then, when it all came out, right? Why keep, so for me, it's like the fact that a managing partner kept HR, I'm like, does that mean that the managing partner was lying? Or did the managing partner just tell HR to lie to me? Or did HR lie to me without managing partner knowing, and then managing partner just accepted it after? I don't know that part. That part I don't know. All I know is that HR, in my opinion, was definitely lying, and the reason I say lying is the pretext that I've been discussing with those different answers to me. Yeah. So I do know that. I believe that. And I do believe that he condoned it by not firing her when he knew about it, you know? So that's right there why I believe that this fits the situation. But yeah, next up on the document, it says a lawyer represents one party to a transaction while also the attorney for the other side. This is a conflict of interest and is generally prohibited unless both parties are fully aware of the situation and consent to it. A lawyer must represent to a client that certain actions have been taken by the lawyer or on behalf of the client. A simple mistake or error in judgment alone is not unethical misconduct. An example of this would be the lawyer's failure to consult with the client prior to writing every letter or prior to filing every document in the client's case. Or perhaps the lawyer's failure to respond to each of the client's telephone calls, inquiring about the progress of the case. If a client has a problem that may be the result of inadequate communication or some misunderstanding, it may be that the problem can be resolved by a frank talk with the lawyer. The client should tell the lawyers that he or she is dissatisfied and should ask for a full explanation. Such a discussion will often eliminate the problem or lead to its solution. Most complaints of attorney misconduct relate to the practice of law. However, conduct outside of the practice of law may result in a disciplinary proceeding if the misconduct reflects adversely on the attorney's character and fitness to practice law, such as dishonest or criminal conduct. So yeah, to be honest though, I do believe that that paragraph does apply to my situation. Both sides of it, from the discrimination case I feel and the fraud case. And I also feel that if the people who left Indeed review or Glassdoor review, I don't know if that's the same person or two different people, because I didn't leave those reviews. And the job title on them were different, but that could have been like the Indeed Glassdoor thing if they made you put certain titles. But yeah, like, I don't know, like if those people complain too, I think under this paragraph that their complaints would be valid and possibly received, and investigated. Like, I feel that speaks to dishonest conduct, in my opinion, because when you look at not only my story but also the other bad reviews from other employees on this firm, it does kind of show, in my opinion, that if what we're saying is true and it's not what's according to their manual, that he's not being a person of his word if he doesn't follow his own fucking manual, and that, in my opinion, is evidence of dishonest conduct, in my opinion. You know what I mean? So I do believe that the people who filed the Glassdoor review and the Indeed review, if that's a people or a person, because I don't know, I literally have not spoken to anybody from that firm since I left. If they did file a complaint, I do believe that they would have grounds to, under the concept of dishonest conduct, if they can prove what they're saying and then compare that to the manual, you can prove he's going against his word, in my opinion. You know what I'm saying? But yeah, that's just my opinion though. But anyway, about forms of discipline. The forms of discipline which may be imposed upon a lawyer for engaging in unethical conduct are private admonition, public reprimand. Okay, so I think I am right, what I had said before. The admonition is private, reprimand public. Okay. And then suspension for a specified period of time, disbarment, and permanent disbarment. I wonder, never mind, I'm processing. I was thinking I wonder why they have different tiers for disbarment and suspension, but whatever. Anyway, I'm not going to get too sidetracked here. But it says private admonition is a form of discipline that is available only before formal charges have been filed and at the discretion of ODC. Once a lawyer has been formally charged with engaging in unethical conduct, the minimum sanction he or she can receive is public reprimand. Okay, so this tells me if he does get charged, I know that it will at least get made public. He has not been charged yet, to my knowledge. I believe it is still under investigation, if I am correct. And he may not even get charged. They could dismiss the complaint for a reason I don't understand, you know? But anyway, then it says the public reprimand is published in the Louisiana Bar Journal and the local newspaper and is typically imposed for minor misconduct. So what I do believe that I can prove fraud. I believe that it happened. I believe I can prove it. And I believe that there is a strong possibility the disciplinary board will recognize that. Or the disciplinary council or whatever. Sorry guys. I don't know what the fuck to call you bitches, but you know what the fuck I mean. But what I don't know is how big of a deal it is what happened. How much trouble is he in? I don't know that part, you know, because I don't know what is the gravity of the situation to them. I know what the gravity of the situation is to me, but I don't know what the gravity is to them. And I find that often the law doesn't typically have the same value alignment as me. But anyway, I'm sorry, what the fuck did I say? Where the fuck were I? Suspension, I'm gonna just keep reading. Suspension is another form of sanction in which the lawyer is prohibited from practicing law for a specified period of time. I feel like they're using the British version of practicing here. Or is it always with an S and I'm stupid? I thought it could be with a C. Yeah. So that's what I was thinking, right? So C is American English and S is British English. Interesting. I wonder if they just copied and pasted their website content from some British shit or Canadian shit. But anyway, it says suspension can range anywhere from 1 day to 3 years in length and may require the lawyer to seek reinstatement to the practice of law, depending upon the length of the suspension. Suspension for a period greater than 3 years is considered disbarment. Oh, well, I was wondering what the difference was. Here we go. Although disbarment is a form of sanction in which the lawyer loses his or her license to practice law, a disbarred lawyer may apply for readmission to the practice of law after 5 years have elapsed from the effective date of the disbarment, unless you're permanently disbarred, right? And then it says the harshest sanction available in Louisiana's attorney disciplinary system is permanent disbarment. If the Louisiana Supreme Court imposes permanent disbarment, the lawyer is prohibited from ever returning to the practice of law. Yeah, that's it. Where a disciplinary sanction is deserved, the actual result will depend upon the nature of the offense and the severity of the lawyer's actions. My thing is, I feel like I gave the lawyer plenty of chances to have conflict resolution, you know, to be amenable, to make things right, to do things in a good way, in my opinion, right? But he literally just, like, in my opinion, treated me like I was nothing the entire fucking time. And so I do feel at this point, like, if he cared about doing things right because it's the right thing to do, he would have already done it. He's had over a year to do that. I do believe at this point that he doesn't care about doing the right thing for me. It's all about doing the right thing in terms of mitigating the punishment that's going to come from the disciplinary board. If there is any sort of like, if he doesn't have an argument for the situation, you know, and all he can do is basically try and be remorseful. I don't believe the remorse, because I do believe if he was truly remorseful, he would have already made amends with me, as I've extended an open arm to do for the last year. I do, so you know what I mean? Like I don't think that he would have, I don't think that he cares about making amends with me. I just feel like at this point he might care about being remorseful to save his job, though. Uh, so because of that, because, I do feel that I don't think that he is going to take an argument in which he's at all admitting anything he did. I think he's probably going to try and fight it and dismiss me or discredit me or something. But I don't know how he's going to do that, because I can see how he could do that with the discrimination case, because it's our words against each other. But when it comes to this email conversation, the email chain is the email chain. You can't change it anymore. It happened already, and I got the proof. So I think now it's just going to be about whether or not the disciplinary board agrees with me. I don't know. But anyway, so let's go look at this video. I'm assuming that it'll probably be hard to hear too. Sorry, guys. But yeah, let's watch this one too.
When lawyers enter practice in Louisiana, they obligate themselves to uphold the law and to abide by the rules of professional conduct. Lawyers who violate the professional and ethical obligations required by the rules of professional conduct are subject to discipline. Lawyers in Louisiana, not taxpayers, pay for the existing disciplinary system, which was implemented by the Louisiana Supreme Court in 1990 with the establishment of the Louisiana Attorney Disciplinary Board.
The court has tasked the board with the responsibility of investigating all allegations of lawyer misconduct and with the responsibility of making recommendations to the court for discipline when warranted. The agency consists of a statewide board, hearing committees, disciplinary counsel, and administrative staff. The disciplinary board is composed of 14 members who are appointed by the Supreme Court. The Louisiana State Bar Association each year nominates one of those members. Of the 14 members, 4 are members of the general public with diverse backgrounds: lobbyists, former mayors, educators, and businessmen. Women comprise 25% of the board, and 1/3 are minorities. The term of office for all board members is 3 years, and no board member may serve more than 2 consecutive terms. None of the members of the board may receive any compensation for their services.
So yeah, basically, I just kind of wanted to bring all of that up because I just wanted to go over all of this, putting this into context, because I feel like it not only helps me understand what could be happening to my case, but it also is helping me process and explain why I decided to file, and what I potentially think could come of it. But yeah. So now I want to just go over the complaint process. I'm not gonna go. You know what? Shit, I think I am gonna go over all of it. Fuck it. All right. So first I'm gonna read this, and then I'm going to go over the diagram. That's how I think I'm gonna do. So, about the attorney discipline, the complaint process. I am totally not speaking correctly. So step 1 is filing a complaint. All complaints regarding attorneys must be received in writing. Complaints can be filed by any person, not just a client, and you could do it in one of 2 ways. I did it with number 2. I wrote them a letter, and I fucking included everything, and yeah. But in here, it doesn't say you have to sign it. They should put that in here, that it needs to be signed, because I don't see anything on here about needing to sign my document. And so for number 2, and so I will say, so they sent that back to me, and they said that you're supposed to sign it, and I was like, oh, my bad, and I signed it, and I sent it back. But it's nowhere on the fucking website, man. Y'all should put that shit on here. Or how often do y'all, I don't know. But anyway, so then step 2, review and investigation. Each complaint is reviewed and screened by the Office of Disciplinary Counsel to ensure that it falls within the jurisdiction of the disciplinary agency and to determine whether or not it warrants a full disciplinary investigation. If the complaint falls within the jurisdiction of the agency, and if no further details are needed from the complaining party at the time, ODC will send a copy of the complaint to the lawyer who is asked to submit a written response to the complaint. If, after completing the screening process, ODC determines that a full disciplinary investigation is not necessary, it will refer the matter to the LSBA Practice Assistance Program for diversion, or simply administratively decline to open and conduct an investigation. So we've already seen that they did open the investigation in our previous stream. So I know that it is occurring. I just don't know what the result will be. If anything has been decided, I was not made aware yet. So yeah, because I know that sometimes they'll be deciding these things, put that shit in writing, and then I don't get the information for days later. Or even if they're doing it online, they'll decide it, but then they don't update the system for me to get information for a week later, is what happened with the EEOC, I think. But anyway, so then it says the complaining party usually receives a copy of the lawyer's response and is asked to submit further comments. So it says usually, not always, right? I, in my case, have not received a copy of the lawyer's response to this situation yet, if they are going to send it to me. Can I ask for that? Should I ask for that? Maybe I should ask for that. Can I ask for that? I'm going to ask for that. I think I'm going to ask for that. Anyway, and then it says, depending on the nature of the complaint and the complexity of the facts, the process of exchanging correspondence could be repeated several times. ODC may also need to interview the parties or other witnesses directly and to obtain further supporting documents. The aim of the investigation is to gather all facts necessary to determine whether there is clear and convincing evidence of misconduct on the part of the lawyer. Step 3. Evaluation and disposition. When the Office of Disciplinary Counsel, ODC, obtains all necessary facts regarding the alleged misconduct, an evaluation is made as to whether there is sufficient evidence to support a finding of a rule violation. Upon the conclusion of an investigation, ODC may dismiss or may recommend probation, admonition, the filing of formal charges, the petitioning for transfer to disability inactive status, a stay, or diversion to the Practice Assistance and Improvement Program administered by the Louisiana State Bar Association. Typically, the investigation will result in one of the following dispositions. There could be a dismissal of the complaint when there is inadequate evidence to support a clear finding of misconduct. The complaining party will be notified of dismissal and his or her right to file a written request for appeal within 30 days of the receipt of notice of the dismissal pursuant to Rule 19. Now, I do think that I definitely have the evidence with what occurred with HR, and I do believe that because they kept HR after my EEOC case, that shows collusion. But what I'm wondering is if they'll legally argue that it was the HR that did it, not him, so therefore he shouldn't be responsible. But at the same time, I believe because he's a managing partner of the firm, he should be responsible. If it was an associate lawyer and then the HR, maybe I could see that argument. But in this situation, he's the managing partner. You know? He's and HR told me that the managing partner was who was telling her to say what she said to me. So you can see why I think that, right? Even if that turns out not to be what happened, but you could see why I think that, right? Based on what was said to me. Anyway, and so then it says, appeals of dismissal are assigned to a hearing committee for review. The hearing committee may approve, modify, or disapprove ODC's dismissal or direct that the matter be investigated further. If the complaining party is still not satisfied, he or she may file a written request for appeal within 30 days of receipt of notice pursuant to Rule 19. And y'all already know if they do dismiss my shit, I'm appealing that shit. I'm going to figure out why they dismissed it and appeal it. I will appeal. I am appealing though. But anyway, in which case the hearing committee's decision will be reviewed by a lawyer member of a panel of the disciplinary board. The board panel may approve, modify, or disapprove the hearing committee's disposition of the matter, or direct that the matter be investigated further. Within 30 days of the mailing of the board's disposition of the appeal, the complaining party may file a petition for leave to appeal to the Louisiana Supreme Court under Rule 19. Leave shall not be granted unless the complaining party shows that the board acted arbitrarily, capriciously, or unreasonably. Imposition of a private admonition, which is the least severe form of discipline. Although an admonition is confidential, it remains on the lawyer's record and can be considered should a future violation of the rules of professional conduct occur. If ODC recommends that the matter be concluded by a private admonition, the lawyer can demand in writing, within 14 days of the receipt of the notice of the proposed admonition, that the matter be disposed of by a formal proceeding. Failure of the lawyer to do so constitutes his or her consent to the private admonition. What I don't get about this part though is conceptually with the private admonition, it's like they're admitting something happened, but then they're saying that if they follow a process, they can ignore it. I don't know. Where is the accountability or the documentation to establish a pattern of behavior in that scenario then? I said in that, not and not. But anyway, fucking. Then it says commencement of a formal disciplinary proceeding, which is marked by the filing of formal charges against the lawyer. A formal disciplinary proceeding is required whenever discipline more serious than a private admonition is believed to be necessary. So a private admonition is like, let's just sweep this under the rug. We know that you did something, but we're going to slap it on the wrist. I feel like that's like whenever like something happened to where they can't dismiss it altogether because they established the fact of finding, but they're still just sweeping it under the rug kind of situation, but throwing the complainant a bone like, yeah, we reprimanded him. I don't know. Maybe I'm wrong for thinking that. But anyway, it says before ODC can file formal charges, it must receive the permission of a hearing committee chairperson. No, I'm not saying chair plural, whatever, chairperson, upon a showing of probable cause. In other words, ODC must demonstrate that there is probable cause to believe that a violation or attempted violation of the rules of professional conduct has occurred, or that there are other grounds for lawyer discipline pursuant to Section 9. ODC's request to file formal charges is presented to the chairperson of a hearing committee, or the regular lawyer member as designated by the administrative committee of the disciplinary board. The chairperson may approve, modify, or disapprove the recommendation of disciplinary counsel, or direct that the matter be investigated further. If the chairperson approves ODC's request, ODC may proceed with the filing of formal charges. The chairperson may grant partial approval on whatever portions of the request meet the probable cause standard. I wonder what the probable cause standard is. Anyway, upon receiving the permission of a hearing, committee chairperson. Why do I keep saying that plurally? Like I keep saying chairperson instead of chairperson. I don't know why. Anyway, upon the committee chairperson, ODC may file formal charges. The formal charges shall give fair and adequate notice of the nature of the alleged misconduct. The charges are filed with the disciplinary board and served upon the respondent pursuant to Rule 19. Service of petition. Service upon the respondent of the petition in any disciplinary or disability proceeding shall be made by personal service, by any person authorized by the chair of the board, or by mailing the petition by registered or certified mail to the primary address shown in the registration statement filed by respondent pursuant to Section 8C or other less known address. Please note that service of proof of attempted service at the respondent's primary registration address constitutes adequate notice for the purpose of Rule 19. Therefore, lawyers shall inform the Louisiana State Bar Association of any changes to their primary registration address. Okay, so now we're going to look at the complaint process diagram. So, first of all, the complaint was received and screened by the ODC. And then they determine if a full investigation is required. So obviously, in my case, they did go with yes here. If they had said no, then it could have been referred to diversion, or they just decline. They usually only decline if it's like not some. Oh god damn it! I just noticed that the Captioner is not working. Because I wonder if it's because. Oh, I just realized that this pop-up is not being shown here. Oh, now I see. My bad. Do I have to do a separate thing for that? Let's see here. Let's see if I can change this. Excuse me. Okay, there we go. So, okay, fucking, where was I? My bad. Yeah, so, usually they'll only decline to investigate, like, if it's not in their jurisdiction, for example, like, if you're trying to, like, because, from what I've read, and I'm not going to pull this information up, but if I'm correct, from what I've read, from other stuff, like, half the cases they get, or half the complaints they get, aren't even about shit they can do anything about. Like, they'll be getting complaints about, people who are not even attorneys, and they can't do anything about that, even if it is a legal matter. For example, so those will get declined immediately. They'll be getting complaints about attorneys that aren't even in Louisiana, so those will get declined. Things of that nature. Or it'll be something where maybe it was an attorney in this area, but what they're complaining about isn't something that is actually a violation of the code of the professional code of ethics, rules of conduct, whatever the fuck they call it. You know what I'm saying? Like that thing, whatever the fuck it's called. But you know what I'm saying. So sometimes, if there's not actually a rule found that they violated, then it'll get declined there. Sometimes, though, there will be a violation will be found, but there won't be much reason to investigate it further, or won't be that big of a deal. Then they will refer it to diversion because they don't need to investigate it, but they do acknowledge that something could have happened, but it's not that bad. And that could possibly be something perhaps, related to like accounting, for example, I'm assuming, depending. But like, yeah. Okay, so say they decide that there's a full investigation required, which based on my communication with them is what I believe happened, then I know that they sent a letter to the attorney requesting a response. So the attorney should have responded within 15 days. I don't know. So I know that they received my documentation. Let me check the exact date here. sorry, I'm checking the exact date that they received my documentation from. I sent it off on August 16th. They should have received it August 19th, if I'm not mistaken. So, August 19th. It is now October 18th. So it's basically been like 2 months. Because of the fact that August has 31 days, I think it technically has been 60 days. Since I filed that complaint. So, and since they received it, and it was signed and everything, and they acknowledged the reception because I have the signed receipt, because, you know, I did the signature to deliver. So, the attorney, they only have, so initially they're supposed to respond within about 2 weeks of that. So over a month ago, right? And if they didn't respond, they would have gotten a subpoena, or they could have asked, from what I've read, they can request an extension for 2 weeks, and if they get subpoena to respond, that subpoena provides 2 more weeks for them to respond. So the most time that they have to respond is 30 days, which would have been a month ago in the middle of September. That's when the disciplinary process should have gotten their response. So the disciplinary process, next up, it says that they review all responses and conduct an investigation, right? So I believe we should be somewhere between the investigation being conducted and an evaluation and disposition of it, right? Somewhere is where I believe we are at, because I have not been informed of anything else yet. So this is where I believe we must be time-wise in this case. So what could happen next? Next up, what could happen is, if they dismiss the complaint, then I'm going to get a notice of that, and so will the attorney. And then I'm going to appeal that shit, and then the hearing committee will review that and all of that. There is a possibility that they decide they agree with me, you know, that something fucked up did happen, but there is a possibility to decide it only needs diversion, since it was HR that actually did these things, even if HR is telling me that the reason HR is doing this is because of the managing partner. And even if the managing partner in email to me authorized HR, they could decide, you know, that since it was the HR that did it, not managing partner, to do diversion. But I do believe, because I can prove in the emails where HR was authorized by managing partner, in my opinion, I do believe that it could escalate from there. And it could go to a private admonition too, but because this issue is something where I believe, you know, it could impact the general public's ability for anybody working for them, you know, to leave in good faith or to have ethical working conditions where their policies are honored. I do believe that it could escalate to formal charges, potentially. So yeah, so next up, we're gonna see what happens if it escalates to formal charges. So I don't know if this is gonna happen or not, you know, but if it does happen, this is what could happen next. The formal disciplinary proceeding process. So there's 3 process steps. First is the hearing on formal charges, then it's the board appellate review, I don't think I'm saying that right, and then it's the Louisiana Supreme Court review. So step one is oh, they got a video here. I didn't pull that video up. Hold on. Let me see. There it is.
Important component.
Yeah, we gotta watch. Why are these so fucking quiet? I tried to bring this up. The other videos are already linked in the description of this video. I'm going to add this video linked in 2 Shakes of a Lamb's Tail. But anyway, okay, so step one, I'm gonna come back to that video after I'm going to read this web page, do the diagram, and then we'll watch the video after. So, step one, hearing on formal charges. A hearing on a complaint is held only if the disciplinary counsel receives permission to file formal charges and thereafter files the charges. When a formal disciplinary hearing takes place, a 3-member hearing committee, 2 lawyer members and a public member appointed by the disciplinary board convenes to take evidence. The hearing procedure is similar to a court trial. The ODC bears the burden of proof. The respondent defends the charges and may be represented by counsel. The complaining party may be called as a witness. Testimony is given under oath and documentary exhibits are submitted. A full record is kept of the proceedings, which proceedings are generally open to the public. Upon completion of a formal disciplinary hearing, a written report is prepared by the hearing committee. The report includes the hearing committee's findings of fact, legal conclusions, and, if the committee determines that misconduct has occurred, recommendations for discipline. Step 2. Board Appellate Review. Oh, we're going to have to watch that too. There's another video. Let me go ahead and pull this up.
Each board panel is also comprised.
Sorry. All right. Review by the board is limited to proceedings in which the ODC or the respondent has objected to the report of the hearing committee. So if nobody rejects, then this part could be skipped, which I would imagine, because at a certain point, right, I have the evidence of what occurred. So yeah, I do believe that everybody's entitled to their own legal defense. So to a certain point, I do believe, everybody should be able to defend himself. But on another level, it's like, the facts are the facts. And if you are trying to act like what happened didn't happen when I can prove it happened, then objecting to these things could come off as if you are misrepresenting what occurred, right? And so that won't go well for you, in my opinion. So there is a possibility that this section could just be skipped altogether, in my case, if it makes it this far. But yeah, anyway, I'm sorry. So where the fuck was I? It says, at the board, the matter is assigned to a 3-member panel of the board's adjudicative committee. Each board panel is comprised of 2 lawyer members, one of whom acts as the panel chair, and a public member. The board's review consists of holding oral argument and reviewing the entire record created by the hearing committee. No evidence or testimony may be introduced at oral argument. If, after oral argument and considering the report of the hearing committee, the board determines that misconduct has occurred and discipline is warranted, the board prepares a written report recommending discipline. The board forwards a copy of this recommendation to the parties. When the board recommends the imposition of suspension, disbarment, or permanent disbarment, the board's recommendation must be reviewed by the Louisiana Supreme Court. If the board determines that public reprimand is appropriate, the board will issue such reprimand. Unless the board's determination is appealed to the Louisiana Supreme Court. Like a private admonition, a public reprimand remains on the attorney's record and may be taken into account should future rule violations occur. The board may also determine that dismissal of the formal charges is appropriate. Absent objection, the board has the authority to dismiss formal charges. And then to the Louisiana Supreme Court review. I'm trying to pull this up on YouTube.
Discipline case.
Okay, so if the parties do not file objections to a hearing committee report, The disciplinary matter proceeds directly to the Louisiana Supreme Court for review. In matters in which the board determines to dismiss formal charges or issue a public reprimand, the court will review the board's determination only on appeal. The court must review a board recommendation to suspend, disbar, or permanently disbar. If the parties file no objections to the findings and recommendation of the hearing committee or board, the court may enter an order based on the recommended discipline with written reasons which may be summary in nature. The court may, however, require briefs and/or oral argument. In the event objections to the board's report and/or recommendation are filed, the matter shall be assigned for oral argument and notice will be sent to the parties. After the matter is taken under advisement, the court will issue a final order of discipline or dismissal. So, I'm going to pull up the attorney discipline complaint process. Not the complaint process, we just looked over that. The formal disciplinary proceedings chart. I have to pull that up, but it's a little finicky. Okay, so the complaint process is what we just went over. The formal disciplinary proceedings is what we are on now. So if those get filed, then they're served upon the respondent, and he has to answer within 20 days. I know that we just reviewed this, but I wonder if they would tell me, like, if he was filed or if he was charged, or if I wouldn't find out until later. But if he was charged already, would I have found out by now? I don't know. Anyway, and so he has 20 days to answer. If he does not answer, then the allegations become deemed admitted, and he has 20 days to request to recall, and then he could go to a hearing on the formal charges or a mitigation hearing upon request. I don't know the difference. But if he answers within 20 days, then we're going directly to that hearing on formal charges. And then either way from there, the hearing committee is going to issue a report and recommendation. So if there is an objection to that filed by anybody, then there's going to be a board argument. And the parties have 30 days to file briefs on that, on the oral argument before the board. But if they don't object, then it's just going to go straight to the Louisiana Supreme Court, and they're going to issue an order. So, yeah, where I think we are is in the complaint process at the evaluation and disposition stage. I think we are here because I have not been notified of either a dismissal or a charge filed. So I do believe there's a possibility that something could have happened and I'm unaware. But I also believe that perhaps we're still in the investigation stage because I have not been made aware of anything yet. And so that is what I have known for sure to have occurred yet. Or so far. Right? I don't know. Words. You know what the fuck I mean. So anyway, so that's our complaint process. So let's go back here. Ooh. Let's see. I don't know why. Okay, there it is. I was freaking out for a second because I was clicking the button, but it wasn't popping back up. Okay. Sorry. Yeah, so that's that. So next step, what we're going to do is go watch these 3 videos on the hearing on the formal charges, the board appellate review, and the Supreme Court review. The board appellate review only happens if there's objections made by either side. If not, then it will possibly get skipped from the hearing to the Supreme Court. So yeah, let's first check out the hearing on formal charges video.
The third important component of the Louisiana Attorney Disciplinary Board is the hearing committees. Presently, there are 38 hearing committees throughout the state. Each committee consists of 3 members, 2 of which are lawyers. The third member is someone from the community and who is not an attorney. None of the members are compensated for their time. Community members who serve on hearing committees come from all walks of life. Their involvement is one of the factors that sets Louisiana's attorney disciplinary system apart from others throughout the nation.
It's an excellent idea to include members of the public in the Louisiana Attorney Disciplinary Board system because this lends a high level of credibility to the process. Over the past several decades, the legal profession and other professions, in the eyes of many, rightly or wrongly, have suffered a decrease in prestige. Lawyers and the legal profession, as well as the public, are anxious to reclaim their justifiable stature. When a public member serves on a hearing committee along with lawyers, this is a way of bringing the public into the tent, so to speak, and this touches the heart of credibility. I am reminded of this every time I sit at a hearing on a committee. My peers and I take this responsibility very seriously. We are keenly aware that we must do our part to help the legal profession maintain the full confidence of the public.
When formal charges are filed and a consent discipline is not agreed to, the case is sent to a hearing committee such as the one I chair, which conducts a formal inquiry into the charges. Good morning, ladies and gentlemen. Let the record reflect that this is a hearing.
The investigation by the Office of Disciplinary Counsel has uncovered a pattern of deceit on the part of Thomas Jones. We will show that Mr. Jones has deliberately misled his clients on numerous occasions, that he has failed to return unearned fees, and that he has deposited his client's money into his own personal account.
May it please the members of the hearing committee, the Office of the Disciplinary Counsel has brought very serious charges against Mr. Jones. It could jeopardize everything he's worked toward during the last 27 years.
Mr. Jones' livelihood is at stake here. He could be reprimanded, suspended, or even disbarred. The hearing committee will conduct a rigorous review of the evidence. Witnesses will be called and documents produced outlining the ODC's case. The accused attorney or his representative will be allowed to challenge the ODC's case through cross-examination and by producing their own witnesses and documents. Following the hearing, the members of the hearing committee will discuss the case. They will then forward a recommendation to a disciplinary board panel.
And what they're saying right here, where it comes to taking this seriously, because this is, I feel like it's not just about me, right? It's about this man's career, but it's about how all employees are treated at that law firm, as well as the standard of how the legal industry treats employees generally, which should be discussed more, because why is it normal for attorneys are overworked, paralegals are overworked, the sales team, I know that's not the correct word, so intake team, whatever the fuck word you want to call it, but shit, man, it's sales, let's be real. The people who answer the phones and the front desk, everybody's overworked, and it's the norm. Every law firm I've ever been in has an extremely heavy case load, and overworking is normalized because systems and procedures are not set up to support the workers, and because there's always going to be more legal cases than there are lawyers to handle it. And so because of that volume for demand, yes, that creates definite because of that demand, that does create the supply and the sustainability for the business, but at the same time, you're always overworked because there's always work to do. And I think that leads to very toxic workplace where social issues are swept under the rug and ignored because everybody is focused on this excessive caseload. And I think that in business, typically one of the reasons that it's so difficult to resolve in the legal industry is statute of limitations. In business, you can use your busy times typically to schedule in your slow times because you have more control of the pacing in a lot of situations. But with the law, there's a statute of limitation on everything, and the court dates are set, and so there are deadlines you have to meet, and it's outside of your control. So because of that, you don't get to control your flow of work as much outside of accepting or rejecting cases. And a lot of lawyers will take on more cases than they can actually handle because they do want to help the public, but then what that does is makes it harder for them to serve the people who are actually paying them. And it's an endless cycle. I've seen lawyers try and mitigate that within different ways. For example, they don't do free consultations, they only do paid consultations, and that's just how they have to do it in order to best serve the people who are paying them so that they can keep going. Others, they create a team. One team handles the lower paying cases or the free paid pro bono cases, and the other team handles the high paying cases. Things of that nature. So I have seen lawyers do try and mitigate that, but in a lot of situations, even if they're not taking on the cases, they're still getting the inquiries and doing the supporting work with that, right? How did I get here? But anyway, I was just rambling because I feel like I understand what it's like to want to be an attorney helping people. Well, I don't understand what it's like to be an attorney, but I understand what it's like to own a business and want to help people with your services. And I think all attorneys get into the legal field for one reason or another to serve the community, right? Because if you want to make money, I know everybody puts on this mindset that if you're an attorney that means you're rich, but no, a lot of attorneys are broke ass bitches too. There's attorneys, especially when you first start out, only making $40,000, especially if you're a public defender. Things of that nature. People have associations with attorneys that I feel aren't true. Yes, it is true that a lot of attorneys just so happen to can be richer because you have to have a certain amount of access to funds to make it that far in schooling and things like that in certain cases, or have access to scholarships or something, right? But on another level, a lot of attorneys, they're just trying to make it just like anybody else. So I feel like I do take that seriously. This is this dude's career. You go to school for this shit. If you lose your ability to practice law, especially for something related to fraud, that's gonna fuck up your ability to work in a lot of places. Yeah. If he doesn't do better, then yeah, I do believe he should be disbarred if he continues on this road and has a pattern and a history of doing this shit. If this was a one-time panicking, I think a 6-month suspension is better because, I feel that experiencing time away to go work on himself and to learn and process and do better and to get some training and to reevaluate how he's moving in business could be good to help him reconcile the harm he's done and to prevent harm being done in the future. But if he's not learning, that means nothing. But anyway, okay, we're just going to watch the next video now. So next up, we've got the board appellate review video here. And these are very quiet.
Each board panel is also comprised of 3 members, 2 lawyers and 1 non-lawyer. The main function of a board panel is to serve as a court of review. The members of the panel review the documents.
Sorry, the captioner is not working. I can't hear shit. Let me see if I can make the captioner work. I don't know what the hell is happening. And putting it in is saying Arabic or something? It's English. Let's see.
Each board panel is also comprised of 3 members, 2 lawyers and 1 non-lawyer.
So the caption's not working still. I can barely hear it, but if I think he's saying that the board, for some reason it thinks he's speaking Arabic. I think he was saying like what he was part of the committee and something about how it's a mix of lawyers and non-lawyers. I don't really know what the fuck he's saying though. The volume on this thing is so low and this captioner is not working.
The main function of a board panel is to serve as a court of review. The members of the panel review the documents submitted in the case, including a record of the hearing. Like a court of appeal, the panel does not retry the case. However, if a manifest error is found in a finding of fact, the panel may correct those findings of fact.
I honestly cannot hear what the fuck he's saying. I hear him saying something about a panel and finding a fact, but I don't know what about it.
Thorough review, and after possibly listening to oral arguments, the panel makes a recommendation of what discipline, if any, should be meted out. The panel's
I heard panel and recommendation, but I didn't hear anything else.
recommendation may be the same as or may modify, either up or down, the punishment recommendation of the hearing committee. 9 members of the adjudicative committee of the board then vote on the panel's recommendation.
I heard they say members of the board vote, but I really cannot hear the rest of that shit.
Once a consensus is reached, the board's recommendation is forwarded to the Louisiana Supreme Court. The justices of the Supreme Court have the final say in what punishment, if any, is warranted.
Okay, I did hear him say that the justice has the final say of the Supreme Court. The Supreme Court has the final say. Okay, that was that. You know, I just realized I had taken this other thing away. I'm just gonna remember to, I just need to remember to link this later. It was auto playing. Okay, these things are so fucking quiet too. I don't know why. I'm hoping the captioner works on this one, but we'll see. Okay, so next up, let's watch the Louisiana Supreme Court review. So the board appellate review, I don't fucking know. I can't hear this shit. I don't really understand what the fuck's happening, but what I do know is if either party has an objection based on the hearing on formal charges, then it goes to an appellate review, if I'm not mistaken. But if nobody objects, then it goes straight to the Supreme Court for review, if I'm not mistaken. And I could be wrong about all of this. But anyway, let's see if we can see or hear what happens here.
When the attorney discipline case reaches the court, the record of the case will be reviewed and, in some cases, oral arguments will be heard.
The Supreme Court of Louisiana has the constitutional duty and right to regulate the practice of law within the state. The Louisiana Attorney Disciplinary Board aids the court in carrying out this important responsibility. The promulgation of new procedures for moving lawyer discipline and disability cases to closure and the establishment of the Lawyer Disciplinary Agency in 1990 has resulted in significant improvements in the processing of lawyer discipline cases. In the past, The inadequately funded lawyer discipline system was burdened by huge caseloads and lengthy delays in the investigation and disposition of lawyer discipline cases. The infusion of much-needed additional funding by Louisiana lawyers and not the taxpayers, the employment of professional staff, and the dedicated service of hard-working volunteer lawyers and citizens who have been appointed to the board and the hearing committees has facilitated a more aggressive and speedy, yet thorough and fair process of investigating and disciplining lawyers whose actions violate the public trust.
Okie dokie. So yeah. And basically the last thing that because we're not going to go through this entire fucking website, but I just wanted to go through like where I think I am now in this journey and why I think so, based on what the information is available to me. And I also wanted to show what I think could be happening next based on what I know now. And so we've kind of, gone over all that through this site. The very last thing I want to go over is the rules of professional conduct. But I'm not going to go over all these rules. What I'm going to do instead is just show you guys and just kind of go over what rules I believe are violated. Ah, shit. I accidentally took this down. Hold on. That's unfortunate for me. Let's see here. So, one rule I don't know if it applies because these other rules I'm pretty sure apply. But this rule I don't know if it applies because it's not about, well, let me just show you. So I don't know if this rule applies. Related to transactions with persons other than clients. Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. Now, the reason I think it may not apply is because it talks about specifically representing a client, when representing a client, and it talks about assisting a client in an act. But why I think this could apply? What about pro se representation of self? You know what I'm saying? I said self, not stuff. Anyway, I understand that technically pro se is in reference typically to litigation and specifically court procedures, but does that apply to any legal paperwork filed by a law office? And if so, then would that not apply in my case based on what we know? I'm just curious. So that's the one that I'm like, I don't think this one applies to me, but I feel like it should, but I don't think it technically does, but I feel like it should. But I don't think it technically applies to me because of the concept of, he wasn't representing a client, he was representing himself, telling HR to do something, right? Unless you want to say he is his own client, but he has an attorney. He should have sought representation on that. Anyway, so, right? So that one, I think we can get caught up on semantics on. It's really up to the Louisiana Disciplinary Board how they do it and see it. So it probably doesn't apply if they do intend that specifically to be about a reflection of clients, right? But anyway, so that's a rule that I don't know if it applies to me. I was questioning it, but these other three rules, I'm pretty sure do apply to me. I don't think it's a question. I think they do apply, but maybe I'm wrong. I could be wrong, but I think they do apply. So first, let's look at here, Rule 5.3, responsibilities regarding non-lawyer assistance. With respect to a non-lawyer employed or retained by or associated with a lawyer, a partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. A lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer, and a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if the lawyer orders or, with the knowledge of the specific conduct, ratifies the conduct involved, or the lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over the person and knows of the conduct at a time when its consequences can be avoided or mitigated but fails to take reasonable remedial action. I think all three of these concepts apply, and both number 1 and number 2 apply in my situation based on what we've been discussing. You know what I'm saying? Because the managing partner in email to me authorized HR to say what she said to me. HR in email to me told me that managing partner was telling her to say what she said. And then the HR did fraud, and I can prove it. I said fraud, not fry. Anyway, yeah. So I definitely believe that Rule 5.3 was violated, and I can prove it. Alrighty, now let's look at what else I believe was violated. Rule 8.4, misconduct. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. Anyway, would have been registered May 10th, 2023. B. Commit a criminal act, especially one that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct that is prejudicial to administration of justice. I believe A through D definitely apply to me, in my opinion. Just saying. And I'm not gonna keep. I'm not gonna keep rehashing why every single time we're gonna be here all fucking day. But you know what I mean. But anyway, and I'm gonna keep reading this, but I don't know if these other letters apply. E, F, G. I don't really know if those apply to me. But I'm very positive that A through D, what we just read, do apply. But it also says state or imply an ability to influence improperly a judge, judicial officer, governmental agency, or official to achieve results by means that violates their rules of professional conduct or law. You know what? Now I do think E applies, because governmental agency, Louisiana Workforce Commission. Hey, yeah, E. This one applies too. Suck my dick. Anyway, F. Knowingly assist a judge or judicial officer in conduct that is a violation of applicable rules of judicial conduct or other law. Or G, threaten to present criminal or disciplinary charges solely to obtain an advantage in a civil matter. So yeah, I think A through E apply to me. And then one more thing. I'm not going to read all of this. I think only Section A of Rule 8.5 applies to me, so I'm not going to read the rest of it. But Rule 8.5, disciplinary authority, choice of law. A. Disciplinary authority. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. A lawyer not admitted in this jurisdiction is also subject to disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. So disciplinary authority, I believe this applies to me in terms of I can prove that the attorney that I'm speaking on is admitted to the state bar in Louisiana. So therefore, I believe that puts him subject to this disciplinary authority of the jurisdiction of the Louisiana State Bar, right? So I do believe that applies to me. So yeah, so now we've discussed, I definitely think that Rule 5.3, 8.4, and 8.5 apply to me. I think it's possible, arguing semantics-wise, 4.1 could apply to me, but I could see how on technicalities, that's not what it's meant for, so it doesn't. But I believe if 4.1 did apply to me, it would be violated. And I definitely feel that 5.3 and 8.4 were violated. And I think 8.5 is why the violation of 5.3 and 8.4 is under Louisiana jurisdiction, given it's a Louisiana attorney. So, yeah. So that's my summary there on what rules I believe were violated and why and all of that. In terms of, what had happened was, and the very last thing I want to go over before we wrap this bitch up and finish is a little Reddit thread reading. So, on Reddit, there's a Reddit thread about Louisiana State Bar complaint, so of course I figured we could read this. Can I zoom in a little? Oh, it's already zoomed in. Whatever, I'm gonna zoom in. That doesn't help. Okay, whatever. All right. So, it's in a Reddit thread called Lawyer Talk, and the initial post here, it says, "What does a bar complaint against a lawyer involve? I am terrified of having a bar complaint filed against me. Maybe it's an irrational fear, but we do have a lot of you lose even if you win cases in terms of New York City housing law. So what happens if a complaint is filed against me? Is it burdensome, expensive, time-consuming to defend against? Anyone with familiarity, feel free to answer." And so let's see what these answers were, just to see what the general consensus in the legal field is of complaints like mine. So somebody said, "The bar will review it to make sure it isn't frivolous before you even know about it in some jurisdictions. You only need to worry if you aren't doing your job most of the time." Somebody else said, "Once had a very angry and aggressive opposing party who kept trying to intimidate me and filed a complaint," it says filled, but I'm assuming they meant filed, "and filed a complaint with the Bar Association. Honestly, I knew I had done nothing wrong, but it still kept me up a few nights. However, my partner reminded me of this sage wisdom. The Bar Association is made up of other lawyers. Think of the worst lawyer you know. That's how hard it is to get disbarred, or even seriously disciplined. The Bar Association are on your side. You're in the club." Somebody said, "Dude sent me a," oh, it's the same person, I think. "Dude sent me a pompous email with a case number. Nobody ever contacted me at all, and I'm pretty sure they read it and immediately threw it away." Somebody said, "What a douche." Someone else said, "That's disappointing." Somebody else said, "So if my lawyer isn't doing their job, you are basically saying me complaining to the Bar Association won't make a difference. So by your comment, you are basically saying you can do whatever and screw your paying clients who are paying thousands of dollars for you to handle a case you said you'd handle. Wow, almost makes folks not want lawyers. I'm so disappointed. I'm going to law school, still never gave me to deal with any lawyer again. I see you hid your name. Cowardly if you ask me." Somebody said this part, "My friend is struggling, begging her attorney to file paperwork for an emergency custody order, and it is taking him weeks. She's at a loss for what to do. I hope the bar does something." Somebody else said, "In the same boat here with my divorce attorney. Not only is he negligent, but belligerent as well. Somebody else said, "My lawyer screwed me up and it's a serious ethical violation. It's impossible to find an attorney to sue him. It's a club. Lawyers aren't there to defend their clients. They are an elite club. I called too many law firms and lawyers to try to sue. They all claim that they don't have the experience in this specific type of case. Only one who is retiring and a few months after being a lawyer for over 40 years came out and told me the truth, because obviously he won't be a lawyer anymore, so he doesn't care. He said, unless you have video evidence that he killed someone, he can get in legal trouble. Otherwise, you're wasting your time. He said that what he is doing to my case and what he did is pathetic, and that I have a strong case against him and against my initial case for what I hired him for, but that there is nothing I can do. It says IAS. I don't know what that means. IAS cases where a lawyer gets in trouble and loses over a low-life criminal are staged to make you think they are just as everybody else. Fact is, they are above the law. Somebody else says, LOL, that's actually manipulation if they are on your side. So meaning they get away with stuff because the bar are a bunch of lawyers? Somebody else said, so what happened? Somebody said, I've had 3 filed against me in 20 years. One was a pro se business owner who filed a bar complaint because I advised him to get an attorney. No joke, that was the substance of it. Only one I had to actually respond to simply because it contained an allegation that I was non-responsive to the client. Easily explained, complaint dismissed. Somebody said, if you do family law, a bar complaint is a badge of honor. Somebody said, what do you mean a badge of honor? I know a lawyer who colluded with his client's ex-family behind the scenes. The whole case was conflict of interest because this lawyer was best friends with her family. Now this person is getting screwed in family law. Somebody else said, I interned with my state's bar discipline board in law school, and I can definitely say that a basic complaint means very little. Most of the time, they send a letter asking for your side of the story. If the complaint then appears to be no more than a dissatisfied or insane client or a mistake, it gets dropped. They don't have time to really investigate most complaints and therefore focus on the ones that seem serious. Unless you screw up your client trust account, they'll take you down for that. Trust accounts is how the attorney that I work for, Chris Zito, that I said I had nothing to do with his shit. That is what he got in trouble for. I had nothing to do with that shit. That's what he got in trouble for, if I'm not mistaken. So anyway, it says, what about an attorney, the next person said, what about an attorney who conceals evidence from a prior investigation that directly relates to a current civil case and deliberately failed to disclose such evidence to the plaintiff, which gives the defense an advantage? Somebody said, got it in a clear pattern? Somebody else says, what about allegations of having sexual relations with a client? And someone said, I am a paralegal. I have worked for attorneys for about 40 years. In every firm I worked, somebody was popped with a bar complaint. I have never personally known of an attorney that was disbarred. Take a deep breath. It would take more than I have seen to be sanctioned. Beware of little old ladies. Somebody said, I've had 2 bar complaints, one from opposing counsel and the second from opposing parties over the years. The bar does an initial review and drops most of them without you hearing about them at all. Then, if it gets past that step, which should be based upon merit but doesn't seem to be, they assign an investigator who sends a letter asking you to respond to allegations. Then, that investigator reviews information, gathers more information, and determines whether to forward the complaint to a bar prosecutor. My complaints involved 1. An opposing counsel falsely alleging that I was mishandling our firm's funds. How would they know that though? And 2. An opposing party saying I violated our rules of professional conduct that prohibit direct communications with represented parties because I had him served at the outset of a case. when I knew he was represented, but his attorney wouldn't accept service. My insurance covers bar complaints defense. They covered the first $5,000 before the deductible. On the first one, I tendered it. It provided a certain account records via my counsel. They closed the investigation. Ended up costing me about $750 in attorney's fees, net to me after the insurance covered $5,000. On the second one, I tendered it, got approval to write the initial response, did so, and they closed it. On the second one, I called an investigator and asked him if he was seriously investigating me for having someone served. He laughed and said, yeah, he wasn't sure why, but his boss told him to send a letter on it. That's just my experience. And then somebody else said, I had an opposing party in a lawsuit file one against me. I went to a diversionary program and got it released. The bar counsel who called me laughed about it. And in another case, most lawyers have complaints filed against them at some point. I want the first 10 of my I went the first 10 years of my career without one, then received 2 in 6 months from former clients. I responded to both and the bar dismissed them. As long as you don't completely screw up, you'll be fine. Somebody else said, if you're in a high volume practice, an emotionally charged practice, and or a practice where your clients aren't very well educated or unrealistic expectations, which you should do your best to manage, then the law of averages says you'll get a bar complaint at some point. I got one 3 years ago on the anniversary of 10 years being a lawyer. Yay! It was from a client that had a drug problem that grew progressively worse throughout representation. Mental health was also an issue. I didn't know about the complaint until the bar sent me a letter letting me know one was filed. They determined it to be unsubstantiated, that they classified it as an inquiry, and that I can represent to any agency that I have never had a bar complaint filed against me. It can happen, but as long as you paper your files and communicate with clients, you likely have nothing to worry about. And somebody else said, my lawyer charged me for evidence, never presented it, which costed me my child custody trial. And somebody else said, my daughter and her friend were rear-ended, and the lawyer they were using ghosted them. And when he found out the lady that hit them didn't have insurance, he has cut off all communication. What can they do to report him? Somebody else said, most complaints are complete garbage and bar counsel should be used to get away from their stupidity. Somebody else said, I'm not a lawyer, but employ them routinely. By far and away, these are smart, ethical people and take their responsibility seriously as an officer of the court. Somebody else said, I own a small company and was sued by a much bigger company that went into receivership. Now I'm learning, this is now I'm learned, but I'm assuming they mean now I'm learning, that the company that sued me owes their company who sued me over $800,000. That makes no sense. Is this okay? It just does not seem fair to me that I really was going against a large legal firm who with much deeper pockets than I have. They did win, and we negotiated a $150,000 settlement, far short of the over $800,000 the legal firm is owed. Does anyone have an opinion? How in the heck can a small company ever win a case with this stacked against them? Yeah, I don't know enough about the law to know what the fuck just happened there, what that meant. So then somebody else said, I would like one of to respond to this. That doesn't make sense. I'm just reading what it says. It said, I fired my attorney for these reasons. 1, he had the wrong date in the memorandum he emailed me. He did not respond for my request for the right date. I had to call the clerk for the date. 2, he showed up with estimates of my retirement accounts after I asked him several times to write a letter to my 401k that they wanted for the amounts he tried to make the deal with my wife, attorney, which was not in my best interest. This pissed the judge off and she came down on hard. I don't know. I read that like it was saying, but I don't know. The next one said, how can you get things like receipts, screenshots, along with an itemized list of the billable hours from an attorney you intend on making a complaint on? Yeah, and then somebody else said, my ex-husband had one. He had to answer it. The issue was actually that my daughter's father wrote the cop, and said I was trading sex for a parenting plan. This wasn't true. We had been dating for months prior to my filing an order of protection against my child's father. My ex-husband and I did meet when he was assigned as my lawyer years ago. That sounds unethical. Or like a conflict of interest. Maybe I'm wrong. And then it says, it's most definitely something he made a big mistake about on many, many occasions. That's not typical though in my experience. We live in a rural state and small city with a big drug problem, and he has a bit of a problem with boundaries. Ethics isn't his strong suit. However, we did like each other, regardless of how we met, and I did ask if it was legal. It is not, but he said that it was frowned upon, but that since we started the openly dating a few years after my case was over, it was fine. When my kid's dad she keeps putting cop in all caps. I think she means cop unless there's something about COP I don't understand. When my kid's dad worked, it says to the cop. I don't know. They sent a copy to my ex-husband. In retrospect, I believe we likely got married due to the accusation, but at the time I was love blind and didn't put two and two together. Anyway, I don't know now how long he knew about the letter, but I see now that it was during that time he began dropping hints about marriage, etc. Like I said, I can see in retrospect that he likely did this to prove to the Commission on Practice that he wasn't doing anything wrong. They took it seriously. We had to respond in writing within 15 days or something like that. We had several friends write letters attesting to the fact that we had a relationship prior to him doing my parenting plan. We had his best friend, a local dentist, and my lifelong best friend write, and we both wrote letters as well. Then we waited. I think we said that we were engaged to be married. We left out the part where we had a sexual relationship while he was representing me years and years ago. We focused on the fact that the relationship as is stood at that time had started prior to him drafting a parenting plan. I couldn't afford a lawyer. My child's father can. I didn't see the point in hiring a lawyer when I was dating one either. The grammar is atrocious, but we're going to keep going. He wasn't really a family law attorney. He did mostly criminal, federal, and state, and had done personal injury in the beginning of his career. Anyway, I got duped. I think now that he started talking about marriage so suddenly because he had received that letter and he knew I was in love with him. It took me years to come to terms with that he might have never loved me. I was another notch in his long notched belt. But yes, they do take them seriously. As in all things legal though, there is enough space to navigate the truth, to fit it into the box they need it to in order to avoid further action. I recall asking why we're saying we were engaged when we had only talked about it recently. And he said that it would just look better. He told me about 9 months ago, after we had been separated for about a year and a half, that he was grateful it happened when it did. That now, 2024, lawyers are told they should immediately get a lawyer if they get a complaint to the Office of Disciplinary Action. That had it happened now as opposed to when it did, he might not have had the same outcome. I think that if it's a client complaint, it's less serious, mostly especially in criminal cases involving public defense attorneys, as they are usually mad about something. He was in private practice, but took contract cases via the OPD. A lot of those clients complain that he never heard about many of them. They choose if it's worth investigating or not. If they think it's worth an investigation, you won't even likely know. If you get a letter, you'll be given a specific deadline in which you must reply. And I guess nowadays the word on the street is lawyer up. But that being said, I met a lot of lawyers, and a lot of them do not follow any code of professional conduct. In my opinion, the ones I know, and some that I like, have less moral high ground than the convicted felons they represent. That might be just an issue where I live. Everyone knows everyone since kindergarten, and there is a lot of people who are tied to the nets, and favors are handed out for having their in with the judges. We have 4 district court judges and a justice of the peace, a few federal judges, and 2 municipal judges. I was the second criminal client my ex-husband represented and married. There are countless he had rendezvous with over the years. So that being said, I think it would be pretty difficult to actually get suspended or lose your license to practice. It just depends on the nature of the complaint. Hope that helps a little. Just have integrity and you'll be fine. Whew, that was a lot. Okay, the next case said, I had a few as a career private criminal defense lawyer, of course mostly from criminals, so they were easy to resolve quickly with no formal action from the bar. Only one made it to an actual hearing in front of the same trial judge who handled the case, who was a cultivated friend. I always volunteered to be, friend is in quotation marks here. It said, I always volunteered to be a major player in all local judicial campaigns. New lawyers need to be intricately involved in judicial politics. Significantly raises your profile within high legal circles. Try to become a player and just really kiss judges' asses. Become active in the local bar association. Get to know which lawyers are on the local disciplinary committee, and judges are tight with the bar inherently. Somebody said small town, and someone else said, no, one of the largest in the country. And somebody else said, I wonder where all those sleazy lawyer stereotypes come from. And somebody else said, seriously, they're not usually this sleazy in public. And somebody else said, lawyers need to be educated of how the burden of proof is on the complainer even before an investigation is opened. The man I thought was my attorney was a predator. I had nothing to gain by complaining to the bar, and I am sure that they can tell who is a crazy willing to waste hours of their time with vexatious complaints. I only wanted to protect other people from a predatory scumbag. Typical ACLU lawyer. Bar complaints should be confidential, otherwise it is discouraging legitimate complaints that protect everyone from bad actors. And that has 10 downvotes, damn, or negative 10 upvotes, I don't know. Anyway, it says, the next one says, it depends on the nature of the complaint. I think they screen it to see if it's something potentially real as opposed to nonsense. There are then escalating steps. You might be asked for an informal reply, and that might be enough. Or it could go further. Obviously, something serious is going to involve contacting your malpractice carrier and getting your own counsel. But anything short of screwing around with the trust account is unlikely to get that far. A colleague of mine, fellow public defender, once got a letter from the bar asking him to respond to a client complaint. They provided a copy of the complaint, which was handwritten, barely legible, and completely unintelligible. He basically wrote the bar and asked, what exactly am I supposed to respond to? I have no idea what this guy's even saying. At which point, they dismissed the complaint with no further action. And somebody else responded, they make you handwrite the complaints. I have no idea why they are still doing it this way, but that is how they want it. A cover letter with a handwritten complaint attached. And obviously, they screened them prior to even contacting the lawyer. Then, an informal reply is asked for, and it is either closed or further action is taken. My ex's complaint was barely legible as well, written by my child's father. It was kind of frivolous. He was just angry and jealous, but my ex was also in the wrong for having relations with a client. And he had done this many, many times, so they did want a reply. I asked him if it was going to get him in trouble. He told me it's frowned upon, but upon further investigation by myself, I learned that the misconduct was actually a violation and could have cost him his career. As it turned out, I was easily manipulated and believed every word he said. I saw him take $10,000 from the trust and leave me for 10 days. He took another client to New York City with money he hadn't worked for yet. I watched him cover his butt by making up billable hours and lying to me about where he had gone. I learned after we had been separated for a couple of years. That could have most definitely cost him that license, but he's still prowling and practicing today." And somebody else said, "In California, it's all done online." And somebody else said, "Hi, your ex-husband had a relationship with a client. Did you report him?" Nah, that was one of the clients. And somebody else said, this is for a different comment altogether. They said, "From what I have learned from others, the bar will review a complaint to see if it merits going forward. If it does merit further investigation, the bar will send the complaint to the attorney and give the attorney so many days to respond with their position. If after the explanation the bar feels there needs to be a further investigation, it will assign a bar investigator to ask the attorney and witnesses questions. Once the bar will manage to settle with the attorney, which can include a private or public reprimand. If you should ever get a bar complaint, do your best to try to get a private reprimand instead of public. Sometimes the matter will not settle and go to a hearing in front of the bar disciplinary panel." And the reason, again, that I believe my situation should be made public and not kept private is if he hadn't had all of these chances to make amends or to do better or to show that he was going to be doing better, to take accountability, then I would be like, let's do an admonition because let's give him a shot, right? But he had shot over a year and he's chosen this path. So therefore, I do believe it should be public for public awareness, because I do believe that people have the right to know that if they engage with this law firm, false information may be legally filed related to their situation, no matter who they are. In my opinion, from my experience, if I understood what was happening to me correctly. So, the next comment here, it says, "Well, are you doing anything wrong? Adhering to ethics rule and otherwise the cover your ass rule. Frivolous complaints from different people, disgruntled clients, opposing parties are filed. The department will give you notice and require you to respond. You can do so on your own or retain counsel to help you. Just make sure that you do respond. The department may be quick or take a while to review and dispose of it. If there is nothing to it, you have nothing to worry about." And somebody else said, "It's mostly smoke and mirrors. Unless you seriously screwed up, unequivocally, the bar is not going to do anything." And somebody has said to that, "Most state bars discipline committees are jokes. In my field of work, most of the BS attorneys write, say, or do which completely violate our ethics and professional conduct would get us barred from ever working again in my profession. Attorneys' rules for ethics and conduct is a fucking joke." And somebody else said, "Well, what do you know? Lawyers talking with other lawyers literally bragging that they have very little oversight because they are part of a club of lawyers that would have a hard time disciplining them. Stereotyping attorneys? Yes, we will. Unbelievable." And somebody had said, "Our country is corrupt to the very fiber it was made from. Scandalous and very shameful people who have no desire to actually be proud of who they are." Let me pause right here. No. Attorneys acting this way are representative of how this country was built, because this country only exists on people using the law and not honoring their word, because if you hadn't fucking broken treaties, we'd still have tribal sovereignty. Anyway, so let's keep going. It says, "They use their degree as an excuse to steal and neglect their job. So sad, and I see now somewhat comical. They fuck you out of money, and because they passed the test, it's okay. Because the same ones judging the complaint are their co-workers, students, friends, their likeness. To me, this is beyond shameful, but it's just a club, I guess dumbass people like me foot the bill." We don't pay for the disciplinary process, though. Anyway, somebody else said, "Just pass the test? Pretty sure that makes up less than, and then, I don't even know, less than 1 millionth of a percentage being an effective lawyer. And then somebody else said, kind of getting the same feeling, peers protect peers. Just imagine getting caught doing some wrong and looking at their clients and say, go ahead, the bar don't help clients. Why complain to the folks who make the rules? And somebody else said, right, I was considering filing one against my divorce attorney. It's a small town. Everyone knows everyone, which means counsel knows each other too. I envision her and the wife's divorce attorney in the conference room having a great laugh and how many lies my wife told, the money taken from me, the bankruptcy I was forced into, etc. I was going to just say fuck it and forget it until I found out that her paralegal's maiden name is the same as opposing counsel. I know 2 people by that name and met them both in my divorce. I don't believe in coincidence, so that may be my breaking point. But I am sure nothing will happen in response to her lack of effort in the case, communication, or interest in giving me any kind of zealous representation. I'm sure if there was a conflict of interest, that would just be kicked under the rug anyway. Somebody else said, this whole thread is disgusting. No wonder lawyers are considered the scum of the earth. And somebody else said, how serious is a IBH hearing? And somebody else said, who do you contact in Illinois about a lawyer and the ARDC? And next up, we've got, what about an attorney who conceals evidence about a previous investigation which directly relates to a current civil case and deliberately refuses to disclose the evidence to plaintiff? Then somebody said, suppose someone files a complaint that's legitimate. Will it be investigated by someone that looks closely at the evidence? And somebody said, and if you have verifiable proof that he's sleeping with escorts on company time, and he's been disbarred before, refuses to pay federal income tax since 2005, and has consequently lost his passport privileges, lied to unemployment to get benefits as well. And then somebody else said, yeah, all you lawyers here, let's be 100% honest here. If you're doing so many cases that it results in you ghosting all my communications, I absolutely will report you. The fact that you need to do X amount of contingency cases to pay your bills and get your kids' teeth straightened ain't my problem. You're my lawyer. I expect you to return my communications in a reasonable amount of time, 24 to 48 hours, after hours if necessary, time away from your kids if necessary, whatever. But ignoring me is not an option. Sure, there are absolutely desperate and neurotic old ladies who call you all day long looking for a big payout for a bullshit case. Absolutely ignore them. But I'm not talking about them. I'm talking about lawyers whose excuse is always, oh God, sorry, there aren't enough hours in the day. You know what? Tough shit. That's your problem, not mine. This goes double for divorce attorneys. If that's your excuse, you seriously need to find another career. And somebody else said, no they don't. They're doing just fine off our dime. And the bar, as we've read in this thread, don't do shit. And somebody said, well, posting Yelp ratings and calling the State Bar Association has worked for me. It's worked so well that when a lawyer called me, he was representing the other side. He said, yeah, we know about you. Your name lights up on Yelp and Google reviews. We aren't going to have a problem, are we? I responded, yes, we are. You represent the other side, so expect foot dragging, non-cooperation, pushback, and also expect to waste your time filing for sanctions against me. And then somebody else said, I will tell you that if you aren't defrauding people, you shouldn't be terrified. If it's frivolous, you won't even hear about it, and it only goes public after an investigation and charges filed. I complained against a lawyer who took my $10,000 retainer and disappeared, literally ghosted me for months, then represented the other party in a contract where I was misled by him, my lawyer, and the other party. He then represented the other party in trying to foreclose on my property. It was a pretty serious crime he committed, and he didn't remember all the documentation I had proving he was retained by me. Such an idiot and a criminal scumbag. He will be disbarred now, as he should. So be a decent person and not a scumbag. No need to be terrified if you just practice ethically and not the stereotypical greedy sociopath lawyer. And somebody else said, last comment here, I have worked for lying lawyers for a very long time. I believe that there should be more bar complaints against them. The things they get away with are unbelievable. So yeah, that was a lot there. But basically, in a nutshell, we can see mixed perspectives on, in the legal community about bar complaints, you know. Some of the lawyers are basically putting in there, like, bar complaints don't mean shit, and so do whatever the fuck you want, basically. And then some of the people who are not lawyers are basically saying, some of them are saying, I complained and I got shit done, and a lot of them are saying that they felt like their complaint didn't mean shit either. So you can see the general consensus of trust in attorneys in there, and you can see that the reasons that many people give for not trusting attorneys is because they don't believe that attorneys are held accountable for their actions. So yeah, I think that is very relevant to what is happening now, because I'm losing trust in a system where people are not being held accountable, you know, and that reflects what happened to me, in my opinion. So yeah, so just to sum up today, you know, it's been a long live stream here. It took me much longer than I thought it would. I thought this would be like an hour or two. We've been here for 3 fucking hours. Whoopsie. Thank you so much for the few people that have actually been watching this thing. That means a lot to me. Thank you. But yeah, so what we talked about today was we really went through we spent most of the time going through the Attorney Disciplinary Board website. We went over about who the board was, what they do, what's the purpose of discipline, and then we also went through what is the process from the complaint process through the disciplinary proceeding process. And we discussed, also, we watched videos in between that about these things, but we also discussed why I complain, why I believe my complaint should be taken seriously, and what do I hope to get out of this situation, you know. We've discussed kind of all of that in here too, and I also did try to recap the situation roughly as well. And we finished up with our Reddit review of what was happening in terms of the legal field. How do people perceive complaints? So we read a Reddit thread about that. So yeah. And I also updated you on my case. We spoke very specifically about where I believe we are in my complaint process based on what I know right now. And in a nutshell, that is, I believe it's still being investigated because, to my knowledge, it has not been dismissed yet as far as I'm aware, and a charge has not been filed yet as far as I'm aware. So I believe the investigation or evaluation stage is happening somewhere along those lines, possibly. So yeah, and that wraps that up. So thank you for joining me today. I appreciate you guys. When I do find out something, whatever that is, I'll update you and let you know from there. If they do dismiss my case, I do plan to appeal it, but I might wait until after I appeal it and then get that response to update you if that does happen. But yeah, I'll let y'all know what happens when it happens. You know, we're just gonna see how this all shakes out. So yeah, thanks for joining me. Hope everything works out and have a good day. Bye. Thanks for watching. Join the loyalty program at noladeathchild.com/loyalty and check in during live streams to get points for rewards.